High Court Civil Procedure of 2018. Now, every court has a procedural rule. The Federal High Court has a procedural rule. Do you understand? Federal High Court has procedural rules. National Federal Court has procedural rules. Federal High Court procedural rules is 2019. So now one cheat code is this. Whenever you have a case in court or you have an issue to deal with, first there are some certain things, there are some certain places you can always find the law that deals on a particular aspect. So if you are in the Federal High Court and you want to know what the procedure in respect to affidavit is, or what the procedure in respect to filing applications like interlocutory applications is, you want to know the law, you want to know what the procedure talks about, just go to the procedural rules of that court. Do you understand? Most of the procedural rules are similar. So you pick the Federal High Court civil procedure rules, you go to a particular order that talks about interlocutory applications, you read about it and you will know that you see what it talks about is what will guide you. Judges themselves, that's what they follow. So if you can know these things very well, you'll know it as well as the judge. It's not something that how will I put it now? It's not something that is not written. It's not unwritten law. They are in the rules themselves. And like Lord Denny will say that on Ikitobi, they will tell you that the rules that they are not made for fun, they are made to guide litigants. So for example, now you have a case now. For example, you have seen a scenario, statement of fact. As a statement of fact, you have been told, it has been stated there that you need to sue for maybe battery, or you need to sue for assault. Are you following? You need to sue for battery or assault. Ordinarily, of course, first of all, you need to know what court you are going to. And depending on how the fact is, you want to know whether the amount of persons you are suing. But first, many times, if you can solve the court you are going to, you have solved, like, should I say 50% of the problem. So if you know the court you are going to, so in a case of battery, where Mr. A wants to sue Mr. B, two civil persons, you go to the High Court of the state in that state. So maybe in Edo State, you go to the Edo State High Court. Then you go to Edo State High Court. Yes, you go to Edo State. You file your action for Edo State High Court. The next thing, after you know the court, the next thing you need to solve is how are you proceeding? What originating process are you using? We have primarily 4 originating processes. We have writ of summons, we have originating summons, we have petition, and we have originating motion. Now, generally, for many civil actions, writ of summons covers them. In fact, even an action that originating summons may be more apposite for. If you use a writ of summons, nobody will penalize you. The difference many times is just the speed. For writ of summons, per your knowledge on Nigerian legal system now.
Yes,
you should know that for writ of summons, you need to call witnesses and the rest. So it's not as fast as the written summons where you don't need to call witnesses. All you need to do is documents and what we refer to as exhibits. So documents and affidavit. So once you've solved the court, the next thing you need to solve is what process are you filing? And generally, to you or to your mind, you know that there are 4 modes by which you can sit an action. So you can go with either of them, or you can go with either writ or originating summons, or petition or originating motion. But it's rarely will you use originating motion. You can use originating motion for fundamental rights, and here you can use originating motion for fundamental rights. But so once you've solved that, you need to solve what originating process you are using. Once all the originating process you are using, our advice if it's your first time, go to the rules of that court and read what it says on the writ of summons. For example, if you pick the Edo State High Court now, you see what it talks about it. Do you have it? Try to download it. Let's go there so that what I'm saying will be practical, not just I'm just speaking theory. So you will see. I will show you. Just download it. When you download it, you see. So those things are very, 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 very. Those things are very, 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 very important. So once you go to the rules and you read the rules, you'll be able to navigate whatever issue you may have. That's the truth. Once you read the rules, you're able to navigate whatever issue you have. So now I think this is 2012. Oh. This is not the latest. This is not the latest, but for the purpose of example, let me show you what I'm talking about. This is not the latest. The latest is 2019. Is it 2019? Well, you just check, but this is not the latest. 2012 is not the latest. So it's either 2018. I think it's 2018. Federal High Court is 2019. Although they are contemplating making a new one now, but now so let me show you. Let me give you an instance of what I'm talking about. 19 summons. Now, if you look at it, look at what this order is saying. Order 301. Celebration of this enactment. Civil proceedings may be commenced by a writ or any summoning motions or petition. Are you saying? Yes, then if you read further, you will see where it talks about if you are using a writ of someone, what you need to file alongside the writ. For example, you need to file your statement on oath, your witness statement on oath. If you are using the witness statement on oath, you need to file your list of documents to be relying upon, list of witnesses that you'll be calling. Most importantly, statement of claim. When it comes to judicial process, the most important document is statement of claim, because the evidence you tender and what the court believes many times determined by your statement of claim. Statement of claim is the foundation, so it's why a statement of claim. Then there's something we call the certificate of preemption counseling. That too. It is there. Everything. What I'm telling you is there. If you read these rules, you'll be able to discuss it just the way I'm discussing it. Do you understand it? It's because I have had the privilege of reading it, and you read it. You certainly read it. You are still coming up, so you certainly read it. But I'm giving you everything you need to know. So no matter what competition you are in, or wherever you go in this world, and you're in a court, and you want to know anything that has to do with procedures with respect to that court, pick the rules of that court and read it. You see it's the rules of the court that contains anything you want to know about procedure with respect to that court. Then also, sometimes if you need clarifications, some of these rules, they've been interpreted in case laws. So sometimes I encourage reading case laws. If it's something you should do. When I started reading case law when I was in 200 level, constitutional law. I started reading case law because I was inspired by Professor Arishi to read case law. Then he was a doctor. I was inspired to read case law. So since then, I've always read case law. I believe. Have you ever used this website called H Briefs?
Yes, sir.
Yes, H Briefs contains many of the cases.
Very helpful.
Yeah, it contains many of the cases I've read, and even today I still read cases. I read a case this morning. I try to read case every morning. Although sometimes there's some morning I may skip, but I try not to skip. If it's a week, I try to read at least every morning. If I want to skip, I will not skip more than 2 days. 2 days. So now, if you read case law expounds, because case law is the living law. Case law is the living law. Case law is where you see the law in action. You know, for example, now what you have in your constitution is just what they've written down. Until it's interpreted by the court, it's just there laying bare. But case law is in case law you will see where the court is giving effect to the law itself. So case law is the living law. Case law is where you see the law as it is. So because the judiciary, they are the ones that give interpretation to the laws. Everybody, you can make law and keep there. There are some laws that have never been interpreted by the courts. And those laws, you may not be certain what the court will do until an action comes before the court in respect to it. So that's for that. So I've told you about the rules of court. Now, another thing that is very important apart from rules of court, apart from rules of court, in respect to procedural law, is Evidence Act. You're informal, so you do evidence. But I started reading the Evidence Act since when I was in 300 level. Yes, I started everything when I was 300 level. Then, because I involved myself, I did a lot of competitions. A lot of competitions. So, try to read the Evidence Act. The Evidence Act is not about 268 sections or thereabout. So, if you read it, you see, because Evidence Act itself is procedural. anything, for example, you are reading anything you don't understand, you can always ask me, what does this mean? I will answer it for you. So when it comes to procedure is simply how you conduct yourself in court, right? And I've told you that when it comes to procedures, whatever the court, wherever you are in the world, just speak the rules of that court to know the procedures and the evidence act of that country. Procedure, when you go, procedure is all about how you conduct yourself in court. So for example, you want to tender a document in court. Primarily we have two types of documents. We have public documents and we have private documents. You will do it. We have public documents, we have private documents. Now there are also two ways by which this document may be proved, either by primary means or secondary means. When we're talking about public documents, we're referring to documents that are kept by public officials. For at this level, document kept by public officials. Private documents that is kept by you. For example, if you should write a letter to me, that was a private document. But for example, how will I put it now? Maybe you go to the police and they take a statement from you. That's a public document. So the evidence has to tell you how to tender these two documents, or when to tender it. So that's what the evidence has. The evidence has to also tell you how your witnesses should conduct themselves in court. The order in which you call your witnesses in court. That's the evidence that. So that's for that. So ordinarily, I've told you what procedural law is. I've told you the cheat code to procedural law. Honestly, whenever sometimes people just come to ask me something that has to do with procedure. They have to ask me something that has to do with procedure. The honest truth is that I don't have any advantage over them. The only advantage I have is that I've read those things. It's just, if they read it, they will know it as well. Do you get? If they read it, they will know it as well. It's just that they haven't read it, or maybe they haven't had the time to read it. I'm not blaming them for that. But what I'm saying is that if they read it, they will know it as well. The lecturers in school who teach us evidence law, evidence act, those are NLAs. They were not born. Were they born with it? They were not. Nobody was born with it. Now they read it, so they read it. So once you read it, you know it. Once you read it, you know it. And also try to read. If you try to read case law, you don't have to maybe if it's one a week you can read, it's fine. Just do what you feel comfortable with. If it's one you can read a week, it's fine. If it's two you can read a week, it's fine. If it's three you can read a week, it's fine. Because when you read it, you always see procedures in case laws. Okay. You always see procedures in case law. So once you do this, I think you'll be cut and dry. You'll be cut and dry. So that's for procedure. I don't know. Do you have any? For now. Maybe something may come to my head, but for now, do you have any questions?
Yes, sir. So I wanted to ask about if moving of motions is contained in each of the court's procedural rules too. How motions
for motions, yes, the rules talks about motions, yes. They talk about motions. However, if you want to move a motion, okay, I will send you if you want to move a motion, is simply you just identifying the motion before the court and telling my lord the date you file the motion, what you are seeking for. Ordinarily, they can read it too, my lord. But you have to do it so that it expedites the process of litigation. So it doesn't seem as if it is slow. So the process of litigation will be fast. So that's it. Okay, for moving motion, I will send you a test. I will send you the procedure and test. It's actually not difficult. It's just about it's what you can do in 1 minute.
For example, if the person wants to respond to a motion, it's via an affidavit.
Yes. If you read the rules now, you see there. If you want to respond to him, somebody has filed a motion. Or I want to file a motion, notice, affidavit, written address. Then if there's an exhibit, or a document, basically can add it. Now, if you want to respond, you respond with a written address and an affidavit. If you have a document, you can also append or affix your document. So that is it. Respond with that. The moving of motion is simply the day the motion is heard. So you come to court that day, I identify those things you file. It's just identifying it. Is it? You just identify. So you have your motion notice. You have your written. You have your motion notice. You have your affidavit. you have your written address, you have your documents. Not compulsory, but if you have documents you want to affix to the affidavit, so that is just for you to, on that day of the court, you simply just add. Let me do a make one for you. May you please quote, my lord, there is a motion notice that has been filed by the applicant. It is dated 6th of January 2025. The motion is brought pursuant to. Have you seen the motion before?
I've heard, even though many of them are not always correct.
No, you see. So first of all, you identify the date. You now the process. The purpose of you doing this is for you to identify your document for those. So you say that the motion is dated 23rd of October, whatever day, 23rd of October 2025. The motion is brought pursuant to section 36 of the Constitution of the Federal Republic of Nigeria. My lord, this motion is spread in honorable court for this. My lord, supporting this motion is a 3-paragraph affidavit or 6-paragraph, however your affidavit will be, deposed to by one Branham Chima of so and so address. My lord, we would like to adopt this affidavit as, if we actually adopt this affidavit in support of the motion. Also accompanying the motion is a written address. And when you adopt the written address, that's all basically. I'll send you the full text, but that's what you do to adopt the motion. So adopting the motion is you simply just identifying the motion and you identify the motion for my lord so that my lord can easily identify it and it's easier. It expedites the process. So that's for that. Any other question?
Okay, sir. I wanted to ask if number one, if a person wants to contest the locus standi of one of the parties, if he can bring it via the motion of notice.
Locus standi, yes, locus standi, you can use via motion of notice, yes.
And number two, if injunctions, if applications rather, application and motions, they can be brought together in the same suit.
Applications?
Yes.
Say come again.
If applications like injunctions, those kinds of things, can be brought together with motion on notice in the same suit.
Okay, this is it. Generally, a motion on notice is an application. So applications are the umbrella term. You know where we have the word, when we say house,
okay,
we have bungalows, we have duplexes. What do you call this type of building? Is it an upstairs? You can say it's an upstairs. Story building, yes, story building, 2-story buildings. But what's the general word?
House.
It's a house. Now, so that's how it is. We have what we call application. You get? We have what we call application. Now, in application, we have motion notice and we have motion ex parte. You can bring your action. Via motion on notice or via motion ex parte. Motion ex parte is when it's required for the other person not to put on notice. But most motions and applications you bring, the other person needs to be put on notice. For example, you are filing an application for locus standi. You are saying that this person does not have the power or the standing to institute the action, and you want to challenge. Maybe the person was not affected, or the person was not affected. The suit is being brought by a person who was not affected. You challenge the local standard of that person. Do you understand? You challenge the local standard of that person. Now, in that scenario, we are referring to local standard. You can bring your application via motion notice because you need to put the other party on notice. The other party is based on notice to come and defend whether or not he has the standing to institute the action. Do you understand?
Yes.
So that's for that. Ask me for that question.
So what of if there are defects as to the mode of making of the other party's written address? For example, there are defects. Maybe they didn't put a stamp.
Yes. That's also procedure. So yes. For example, if their document is not signed, and that's something you can raise. It's something you can raise an objection to. That one you don't even need to file any motion. You raise it on the court, on the spot there. Do you understand? You raise it on the spot. Because every document that is not signed is worthless. Then we also did put stamp. Because if the Legal Practitioners Act and the rules of personal conduct for legal practitioners talks about a lawyer putting a stamp in every document he prepares. So in a situation where a court document there is no stamp on it, yes, you can raise an objection on that. Although there will always be a reply from the other side. When you raise it, that's a good point on which you can raise an objection on.
So would there be would there be an excuse? Would it be an excuse rather if the person wants to regularize it in court? There in court, can the other party, like person that is raising it, say that okay, they can't like regularize that?
Yes. It just depends on how you present your argument. But whatever you are presenting, you should make sure that you have a good foundation for it or a good principle of law backing it. And law itself is logic. So if you can wire your logic, for example, maybe you raise the point that it's not signed and you want to sign it there. You say no, that you can object, you can oppose it, say no, that it should not be signed now. It should not be signed now, that what ought to have been done ought to have been done. Do you understand? So they cannot sign it now. If I thought they want to sign it now, you can ask for cost. You ask for cost. You know what cost is? Cost is, for example, if somebody has done something wrong and the person has wasted your time. If anybody wastes your time in court and the person is seeking to amend his process, or whether seeking to amend his process or whatever the case will be, but as far you are sure that your time has been wasted, you can ask for cost. Cost is simply you tell my lord that my lord will ask. For example, they say they want to sign it there in court. You say, my lord, we oppose to them signing their processes now in court. It's something that they ought to have done. However, if they want to go ahead and sign it, to be asking for cost. That's say, my lord, we are asking for 100,000 naira cost. Your cost is your expense. For example, maybe if you've used 50,000 naira going to court, you can ask for 100,000 naira cost. Do you understand? So, there are two things. Either you oppose it, alternatively, say that if my lord wants to grant them and allow them, despite the fact that they've made a mistake and your time has been wasted, you ask for cost. Do you understand?
Yes.
Yeah, so you ask for cost. Do you have Judy? Does Lover still do Judy?
Judy legal.
Yeah.
It's not frequent. It's been a long time, sir.
We are doing Judy that year now. I introduced Judy during my time. Judy legal. I made Judy legal available for law students. How much? Was it not 1,000 naira?
Yes,
I can't record the price, but I think it was very cheap. It was 800 naira. Was it? Yes. It should be around 800 naira then, or 1,000, because I know it was the normal pricing then was about 1,500. So for law students, you pay 700. I think it was 700. During my administration as global chairman. So that's what we were doing. It's just funny that that's the thing. When successive people who do not, like, maybe they don't read case law, maybe they have a different idea. But case law is something that the reason I was asking is that if you have judicial legal, or you have law pavilion, or you have anyone, you just go on the platform, type cost. You see authorities on cost. Just read the authorities on cost. Go there, type local standard, see what the court has said on local standard. You get the time maybe you used to do Facebook or WhatsApp. These days we're always on our phone. The time you used to do Facebook or WhatsApp, just go there, type
cost.
Type cost or type cost or anything, affidavit. Any authorities will come out on affidavit. Do you get?
Yes.
You just read and you build your knowledge. Life is all about knowledge. Because this I think there's a quote that what you don't know is bigger than you, something like that. There's a quote like that what you don't know is bigger than you. So if you know something and you have knowledge on that thing, people can't cheat you. So that's for that. Further questions?
Not really, sir. Yes, sir.
Okay, but do you understand what I've said on procedure?
Yes, sir.
Are you sure?
Yes, sir.
So that's procedure. Like I told you, if you want to know procedure, so let me just sum it up. There are three procedures. Number one, the rules of court. Wherever you are in the world, it's a general principle. The rules of court will tell you the procedure. The Evidence Act will tell you the procedure. Or case law. Case law will expound it. But ordinarily, primarily, you find it in the rules of court and the Evidence Act. And there are some procedures you may see some other. For example, something like Company and Allied Matters Act. You will see some procedures there that are not in the Evidence Act, but those are for matters that are very external. Do you understand? And when you want to deal with matters like that, you will know. So those are for matters that are very external or extreme. So that's for that. So I don't know. Are there further questions?
Yes, sir. How about international laws, sir?
International law. Well, for example, maybe I did Nuremberg. I did Nuremberg twice. I did African Moods twice. I did Nelson Mandela. Is it up to 3 times? I did a lot of competitions. But the only time when I go through my CV, when I go through my CV, that's when you see. When I go through my CV, that's when you see a lot of stuff I've done. So that's what that. Yeah. So when international competitions, basically, for example, maybe you're doing Nuremberg. First of all, every court has a rule. Nuremberg, you take it to Nuremberg. There's a Nuremberg court. There's a Nuremberg court. You have heard of International Court of Justice?
Yes, sir.
You have heard of ICC, International Criminal Court?
Yes, sir.
Those courts have their rules. They have their rules on procedure. If you type it on Google now, what is the rules of procedure for ICC, International Criminal Court? They will tell you the document. So just for you to pick that document and read what it says or what you are looking for. So if you are looking for maybe jurisdiction, if you pick, for example, the Rome Statute. The Rome Statute governs international. The Rome Statute governs international criminal. International crime. So if you pick it, you will see procedures of it. So there are plethora. Just what I told you is all you need. What I have told you now is all you need. The rules of the courts is one, then the Evidence Act, then case law. A case law only interprets. So that's all you need. There's nothing.
Similarly, also in criminal matters too, criminal proceedings, also the rules of the court and the Evidence Act.
For criminal matters, now that's a good question. For criminal matters, courts do not make rules for criminal matters except in very few cases. Usually just the Administration of Criminal Justice Law, Administration of Criminal Justice Act. So if it's a federal court, Administration of Criminal Justice Act. If it's a state court, Administration of Criminal Justice Law. So that's the procedure. In that document, there are up to 400 sections. You see all the procedures you need there. Do you get?
Yes, sir.
So,
sir, please, do you have any book or something about examination in chief, all of this?
There's this book, Devil's Advocate. Have you read it?
Yes, sir.
You've read Devil's Advocate?
Yes, sir.
Can you remember the author? It's written by Molly. Do you have it?
Yes, I have it as well.
Read it now. I think that's the only book. That book is very good. It's written by, if you check it, if it's one written by Molly, Iain, and that's his name, Iain, then Molly, Morley. If it's that one you have there, you are good to go. That book is very opposite when it comes to cross-examination. In fact, that book will tell you that if you have a case, the first thing you do when you have a case is to write your final written address, because that's your storyline ordinarily. It's from your final written address. That's when you now plot every other thing. Statement of final written address is what you want. It's your conclusion of the case. It's from your final written address that you now plot your statement of claim. That you now have to tailor your witness statement on oath to. So I think that's it. That's good. So apart from that, I don't think there's any other thing. But if you have a question subsequently, you just test me. The reason why we could not meet this day was that I think I was very busy. The day before when were we supposed to meet? Say after your exams, right?
Yes, sir.
I think I last week I traveled to the village last week Wednesday. I came back on Tuesday, so I was not in Benin at all. Then on Wednesday I was at the law fair. Yesterday I was busy, so today was the day that was free for me. But I like the fact that you were diligent enough to disturb me, and secondly, I think you were point for two in comment. So that's something that is good. So all you have to do now is to, whenever you have a situation that you're dealing with, just know first of all, know the court, pick the rules of that court, then you read whatever you want from the rules of the court. Do you understand? Then if you are dealing with that issue and maybe it's bigger than you or something you cannot deal with, you can always ask me on my WhatsApp. You understand? You can always ask me on my WhatsApp. So I think that's that. How did you go?
From the faculty I took a cab. I didn't actually know this place before.
Okay, you don't come here before. But you can walk down now.
Yes.
You can walk down. See as they are walking, his brain starts. You don't have to. Yeah, but as you are going, you see their bus.
Yeah, I have both of you.
See how testing?
Yes.
Where? Economy is not far now.
Yes.
Economy is not far, yeah. I know that you walk like this.
Yes.
Not far.
Thank you very much, sir.
So that's what you have to do.
Yes, sir.
You have to have questions that make us ask me on my WhatsApp.
Okay, sir. Thank you, sir. If